A Guide for Immigrants Accused of Crimes in Florida. Written by Joseph Mitkevichus. If you're detained by ICE during or after the criminal case. Sometimes ICE, Immigration and Customs Enforcement, will detain an immigrant during the criminal process. For example, right after an arrest or if you bond out of jail, as we discussed with detainers, or after the criminal case is over, especially if you end up with a deportable conviction. Being in ICE custody means you are now dealing with the immigration system, which has its own rules. Here's what to expect and do. 1. Transfer to ICE custody. If ICE picks you up from jail, they will transfer you to a federal immigration detention center. In Florida, ICE detainees might be held in facilities like the Baker County facility, Glades County, or others, or even outside of Florida if beds are full. Your family can use the ICE Online Detainee Locator, Google it, with your alien number, A number, or other info to find where you are. It may take a day or two for you to be in the system. 2. Right to an immigration hearing. In most cases, you have the right to see an immigration judge who will decide if you should be deported or can stay. This is separate from your criminal court. It's important to know, immigration proceedings are civil, not criminal. You do not get a free government-appointed attorney in immigration court. You have the right to hire an attorney or find pro bono help, but if you can't, you'll have to represent yourself, which is tough. The judge will hold a hearing called a master calendar, where you or your lawyer will respond to the charges of deportability, and later an individual hearing to present any defense. 3. Mandatory detention. Some offenses trigger mandatory detention under immigration law. This means ICE cannot release you on bond while your case is ongoing if you have certain convictions, notably aggravated felonies, many drug offenses, some CIMTs. If you fall under mandatory detention, you'll have to fight your case from inside the detention center. There's no option for an immigration bond. If you are not in mandatory detention, you can request an immigration bond hearing to ask the judge to release you on bond. At that hearing, you must show you are not a danger to the community and not a flight risk. They'll consider your criminal record and ties. This is where having family letters, etc. helps. Immigration bonds can be high, often $5,000 to $15,000 or more. If granted and paid, you can be out while the deportation case proceeds. 43. 4. Removal. Proceedings. The deportation case will consider your criminal conviction and any other factors. If you have a deportable conviction and no way to avoid the legal consequences, the judge might order you removed. However, you might be eligible for some form of relief from removal. Common forms of relief include cancellation of removal for LPRs. If you're a green card holder for at least 5 years and lived in U.S. 7 years, you can ask for this if you don't have an aggravated felony. It's a one-time chance for the judge to let you keep your green card because of equities like family and long residence. A criminal record makes it harder but not impossible if the crimes were not too terrible. Cancellation of removal for non-LPRs. If you are undocumented or on a visa and have been in the U.S. for 10 plus years, have good moral character, and your U.S. citizen or LPR spouse, child, or parent would suffer exceptional and extremely unusual hardship if you're deported, you can ask for this. Again, certain convictions disqualify you, and it's hard to meet the hardship standard. Asylum or withholding of removal. If you fear persecution or torture in your home country, you could apply for asylum if within 1 year of arrival usually, or withholding, no time limit but higher standard. Serious crimes will bar asylum. Aggravated felons are barred from asylum and even from withholding in many cases. But if you fear severe harm, let your lawyer know. Sometimes even criminals can't be deported to certain countries, if more likely than not they'd be tortured. That's the Convention Against Torture Relief. Voluntary departure. If all else fails, sometimes you can ask for voluntary departure instead of a removal order. This means you leave at your own expense, but it avoids a formal deportation on your record, which can make it somewhat easier to return legally one day if eligible. You still have to leave the country, but it's a more dignified exit. 5. Family's role. During ICE detention, if you are detained by ICE, your family can help by finding you an immigration attorney. This is crucial because immigration law is complex, and you'll be up against government attorneys. As mentioned, there is no public defender in immigration court. Organizations like Catholic Charities, Americans for Immigrant Justice, or private lawyers can represent detainees, sometimes even pro bono if you qualify. Making sure you get important documents. Your family should gather documents that might help your case, such as proof of your life in the U.S., lease, bills, children's birth certificates, marriage certificate, tax returns, letters from community or church, etc. These can show the judge you have a life here, worth sparing. Attending the immigration hearings if possible. Seeing loved ones in court can sometimes humanize your case. Helping pay for an immigration bond if one is granted. They should be prepared for possibly high amounts. 6. Coordinate with criminal case. If your immigration detention happens before your criminal case is finished, say ICE picked you up after you bonded out, but your charges are still pending in criminal court, it gets complicated. You definitely need lawyers to coordinate. 7. If you win your criminal case, if your charges get dropped or you're found not guilty, and ICE still has you, you can argue to the immigration judge that you are not deportable, if no other issues, and should be released. However, note, even without a conviction, ICE can still try to deport someone who's undocumented just for being present without permission. They just won't have the criminal grounds. They'll use the no legal status ground. If you had status, like green card, and you beat the charges, then you usually won't be deportable for those, and ICE might close the case. Immigration judges see many cases where the criminal side is resolved one way or another. They look at the final result. 8. If you lose the criminal case. If you are convicted, then the immigration judge will see if that conviction fits a deportation ground. We discussed which ones do. If it does, you'll likely be ordered removed unless you qualify for relief. Sometimes timing matters. If your criminal appeal is pending, you can ask immigration court to wait. But if it's a final conviction, they move forward. 9. After deportation order. If the judge orders you removed, deported, you might be physically removed from the U.S. soon after. Depending on the country and travel arrangements, sometimes within days or weeks. You may have some appeal rights. You can appeal an immigration judge's decision to the Board of Immigration Appeals, BIA, within 30 days, but you'd need a lawyer to do that usually. And if you're aggravated felon or certain crimes, you might have limited appeal options. If you take voluntary departure, you'll have a short deadline to leave on your own. Facing an ICE detention and deportation process is tough, but remember, you still have rights. The right to an attorney at your own expense or through a nonprofit. The right to a hearing in most cases. You generally won't be deported just at the snap of a finger. You see a judge. The right to contact your consulate, similar to the criminal side. The right to present evidence and defend yourself in immigration court. It's a lot to handle, which is why having a trusted lawyer and the support of family is so important. The best scenario is to avoid a conviction that puts you in this situation. But if you do end up in ICE custody, focus on the new battle. Get an immigration lawyer. Figure out if you have any legal relief, and continue to fight for your right to remain with your family.